Hello friends, this is Hatim Rampurawala, and in this video we will revise in the Insolvency and Bankruptcy Code 2016. Basically this is the amended the sheet which we are referring for IBC code is amended for November 20 as well, means amendments, and that too again we will see the amendments separately so that we will get a clarity what are the basically amendments from May to November 2020. Okay, so we'll start directly. Introduction. See this would be a revision lecture basically, so I would not be going into much concepts. At some points we would be just read through and proceed further. Okay. Introduction. The term insolvency can be used for individuals, and insolvency can be used for individual as well as corporate organization and corporates. For individual it is known as bankruptcy, and for organization it is known as corporate insolvency. If in case of an individual it is untreated, the insolvency will lead to bankruptcy. So in individual case first it is individual case it is known as bankruptcy, and if it is untreated, insolvency will be lead to bankruptcy. And in organization it is a corporate insolvency. If it is untreated, if the insolvency is not treated, it will lead into liquidation. Features of the Insolvency and Bankruptcy Code: it is a comprehensive law, no multiplicity of the law, one window clearance, one chain of authority, low time resolution, priority of the interest of the workman and the employee, and it has provided the new regulatory authority. Okay, so these are the features, that is comprehensive law. Then there is no multiplicity of law, no two or more law are there who will coincide with each other. One window clearance, all issues will be resolved through this code, through the authorities specified under this code. One chain of authority, low time resolution base, that is 100. It will be done the IBC. In IBC the insolvency process period basically is 180 days. Which can be extended further. One time extension has been granted of 90 days. We can be granted of 90 days, and there is again a higher cap limit of 330 days as well. Okay, that we will see further. Then priority of the interest of the workmen. In this code they have given the priority in case of any liquidation. So if there is a liquidation, so priority will be given to the workmen, payment of the dues to the workmen and the employees. And there is a new regulatory body, that is Insolvency and Bankruptcy Code in this established. Okay, there are 5 pillars to the regulatory mechanism. Insolvency and Bankruptcy Board. So there are 5 pillars. First is Insolvency and Bankruptcy Board. This is the board basically. The code provides for the establishment of the regulator who will oversee the entity and to perform the legislative. So this code basically provides a regulator who will oversee, who will oversees these entities to perform legislative, executive and co-judicial function with respect to the insolvency professional agencies and information utility. Now insolvency professional agency, if I say in one term, it is not similar, but it is you can take an example that insolvency professional agency is an ICAI body. Insolvency professionals, you can consider it as a CA. So CA are the members of the ICAI. Likewise insolvency professionals are the member of the insolvency professional agencies. This insolvency professional agencies carry out regulatory, executive and co-judicial function. See insolvency professional agencies, the code provides for the establishment of the insolvency professional agencies to enroll and regulate the insolvency professional and its member as its member. So it provides the establishment, setup of the IPA, that is insolvency professional agencies. What the agency will do, that is to enroll and regulate the insolvency professional. These insolvency they will enroll and they will regulate the insolvency professional as its member. So these IP will be the member of IPA. IPA, that is insolvency professional agency, will perform 3 key functions: regulatory, executive and co-judicial. Regulatory, that is drafting detailed standards and the code of conduct. So they will draft the legal standards, code of conduct. This insolvency professional agency will do. Executive, that is monitoring and inspecting the members on the regular basis. So regulatory is drafting legal standard, code of conduct. Executive, monitoring and inspecting the members on the regular basis, gathering information on their performances, and malfeasance in the conduct of the insolvency professional duties. So what is the what is their performance? Is there any malfeasance in the conduct of the insolvency professional duties? And they will also perform quasi-judicial function, basically, that is addressing grievances of the aggrieved party. So I will read it again. The code provides for the establishment of the insolvency professional agency to enroll and regulate the insolvency professional as its member. The IPA will perform three key functions: regulatory functions, executive functions, and co-judicial. Regulatory, that is drafting detailed standard and code of conduct. Executive, that is monitoring and inspecting the members on the regular basis, monitoring and inspecting members, regulating, gathering information on their performances and malfeasance in the conduct of the IP duties, that is insolvency professional duties. Co-judicial, that is addressing the grievances of the aggrieved party. Then third is insolvency professional. These are the professional individuals, basically, who what we can say are which are appointed by the what we can say NCLT on admission of an application, and what we can say they carry out, basically they manage the business of the debtor. So board of the debtor is set aside. Their powers has been taken and it has been given to insolvency professional who manage the business, who carry on the business as a going concern. And then the whole entire process has been done of insolvency IBC, that we will see the process and what is the role and what is the duty, what is the function, what is the power of insolvency professional. So we will read out the what is exactly given over here. The code provides for the insolvency professional as an intermediary who would play a key role in efficient working of the bankruptcy process. So these individuals, basically these professionals, as an intermediary, they are as an intermediary who would play a key role in the efficient working of the bankruptcy process. Bankruptcy, we can say, it is termed in case of an individual, and corporate insolvency is in case of corporate persons. Okay, in the insolvency process, the insolvency professional verifies. So in the insolvency process, the entire process, insolvency professional verifies the claim of the creditor. So their function, basically, this is given, this we will see further as well. They verify the claim of the creditor, then they constitute the creditor committee, runs the debtor management, as I said, they runs the management during the moratorium period, and helps the creditor in reaching the concise consensus for a revival plan. And they help, basically, the creditor in reaching a consensus for the revival plan. So what they are given is that insolvency professional verifies the claim of the creditor, constitute the creditor committee, runs the debtor's business during the moratorium period, helps the creditor in the liquidation. Insolvency professional act as a liquidator and the bankruptcy trustee. If it is in case of corporate insolvency, we can say, so this insolvency professional can act as a liquidator as well, act as a liquidator and bankruptcy trustee. Okay, and the fourth pillar of the IBC. So the first was the regulatory body who will oversee the entities to perform the legislative, who will oversee all these entities. Which all entity? Insolvency professional agency, insolvency professional and information utility, and to perform the oversee the entities and to perform the legislative, executive and co-judicial function. This insolvency professional agency are the establishment of the insolvency professional to enroll and regulate the insolvency professional as its member. So what it is given in IPA is that it is an establishment for to enroll and regulate the insolvency professional as its member. It performs the key functions, that is regulatory, executive and co-judicial quasi-judicial function. And it is given regulatory, that is drafting standard code of conducts, executive monitoring, inspecting the member on the regular basis, gathering the information on the performances and the malfeasance in conduct of an IP insolvency professional duties, co-judicial, addressing grievances of the aggrieved party. Then insolvency professional, as we have seen that they insolvency professional as an code provides for the insolvency professional as an intermediary who play a key role in the efficient working of the bankruptcy process. In the insolvency process, they basically verify the claims of creditor, constitute the creditor committee, runs the debtor business, help the creditor in liquidation. Insolvency professional act as a liquidator and the bankruptcy trustee. Information utility, the code envisages creation of the information utility to collect, collate, authenticate and disseminate financial information of the debtor in the centralized electronic database at all the times. So information utility basically contains all the information, the management information of the corporate debtor. What are loans, or what are borrowings are there of the debtor, what is the charge created, then who all are the creditors, is there any default, or how much is the default, who are the parties, means entire data of the corporate debtor basically we can say is in the electronic form, is it with information utility. See, the code envisages the creation of an information utility to collect, authenticate and disseminate financial information. Financial, basically the information is also financial information of the debtor in the centralized electronic database all the time. It requires the creditor to provide the financial information of the debtor in the multiple they are not referred to any other information, but only the financial information of the debtor in the multiple utilities on an ongoing basis. Such an information would be available to the creditor. So the creditor provides the information utility with all these financial information, then these information can be used by the would be available to the creditors, insolvency professionals, liquidators, other stakeholder in the insolvency and the bankruptcy proceedings. So in the insolvency and bankruptcy proceedings, this information which is with the information utility in the centralized electronic database is available to the creditor, insolvency professional, liquidator, other stakeholder in the insolvency and bankruptcy proceedings. The purpose of this is to remove the information asymmetry and dependency on the debtor's management. So the insolvency professional or the creditor or the, we can say, liquidator or other stakeholder do not have to what we can say, rely or do not have to depend on the data's management, but they can get information from the information utility for the critical information that is needed to swiftly resolve the insolvency. Last is adjudicating authority. NCLT is the adjudicating authority in case of an corporate insolvency, and DRT in case of an individual. See what they are given is adjudicating authority for the corporate insolvency and liquidation is the National Company Law Tribunal. Appeal against the NCLT order shall lie with the National Company Law Appellate Tribunal, that is NCLAT, and thereafter to the Supreme Court for individuals and others. So that was for the corporate persons. For the individuals and the other person, the adjudicating authority is the Debt Recovery Tribunal. Appeal lie to the Debt Recovery Tribunal, DRAT, and thereafter to the DRT, then appeal to DRAT, and then to the Supreme Court. Applicability of the code. This is an amendment. Earlier it was like for part 3 there was an exception to Jammu Kashmir, but now the entire India is covered for each and every part. That is, as per section 1, it extends to whole of the India. Okay, we'll move further. The code shall apply to the code basically applies to the companies governed under the Companies Act 2013 or any of the previous law, any special act. LLP, so it is applicable to the companies, government companies, say governed by the Companies Act. Then LLP, governed by the LLP Act. Notified body corporate, so these all are the body corporate. Company is a body corporate, LLP is a body corporate, notified body corporate. Then partnership firm and proprietorship firm. Partnership firm, that is there are partners, and proprietorship firm, individual person who carry on a business. Personal guarantor to the corporate debtor. Any personal guarantor, we can say that a debtor basically, director. So personal guarantor to the corporate debtor, individual other than personal guarantor. So these, to all these individuals, to all these entities, all these persons, what we can say, code is applicable. Companies, LLP, notified body, partnership firm, proprietorship firm, personal guarantee to corporate debtor and individuals other than personal guarantor. The code shall not apply to, this is important para, the below one. The code shall not apply to the corporates in the financial sectors. Thus the code does not cover bank, financial institution, insurance company, does not covers the code does not cover okay, wait a second, it does not applies to the corporates in the finance sector. Thus the code does not covers bank, financial institution, insurance company, asset reconstruction company, mutual fund, collective investment scheme, pension fund. However, CG can notify the financial service provider for the purpose of the insolvency and the liquidation proceedings which may be conducted under the IBC in consultation with the appropriate financial sector regulator. So what they are given is, however, the CG can notify the financial service provider for the purpose of the insolvency. So basically IBC code is not applicable to this financial sector, but CG can specify certain, they can notify the financial service provider, they can notify any of the financial service provider if they wish to any they can notify any financial service provider for the purpose of the insolvency and the liquidation proceedings which may be conducted under the IBC in consultation with the appropriate financial sector regulator. In consultation with the appropriate financial sector regulator, NBFC including the housing finance company with the asset size of 500 crore rupees or more as per the last audited balance sheet have been notified with the RBI as its regulator for the purpose of this code. So NBFC including the housing finance which has an asset size worth of 500 crore rupees or more as per the last audited balance sheet have been notified by the RBI as its regulator, have been notified as its regulator for the purpose of the code. Okay, important points from some okay, so this definition, some important definition, we will cover it later on. We will directly move to the we will directly start with insolvency, corporate insolvency resolution process. In our syllabus of CA final, we just have the part 2 I think so is for corporate insolvency for the corporate person. So we just have the corporate insolvency and not other bank means to individual or any other entity. We just have corporate insolvency resolution process. First there should be commitment of default. Okay, so over here also there is an amendment. The trigger event for the purpose in the occurrence of any default occur when the whole or any part of the amount of any debt has become due and payable and is not paid by the and is not paid by the debtor. The provision shall apply only when the amount of any default. So the provision of what we can say, the trigger point for insolvency professional means IBC, the code to attract is there should be a default. The provision shall apply only when the amount of a default is greater than equal to 1 crore. See, this was earlier 1 lakh which the central government has the power that they can extend it up to maximum of 1 crore, and now they had exercised their power and it is now 1 crore limit. That is, the default should be greater than or equal to 1 crore. If the default is of 1 crore also, IBC will be attracted. It is greater than equal to 1 crore, section 4. Then filing. So once the default has been occurred, so application will be filed before the NCLT. The corporate insolvency process may be initiated against any of the defaulting corporate debtor. So this process is initiated against whom? The defaulting person, that is the defaulting corporate debtor, by making an application for the purpose of the insolvency resolution. The application may be made by three entities basically can make an application. Here it is, that is operational creditor, financial creditor and corporate applicant. There is a definition of corporate applicant that we will see. So we'll first see financial creditor, that if financial creditor files an application, financial creditor itself or jointly with other financial creditor or any other person notified on behalf, that is guardian, executor or administrator of the estate, trustee including the debenture trustee, person duly authorized by the board. Okay, so either they can make joint itself, it can make an application, that individual whose default has been committed basically, not whose default basically, and there is a financial creditor whose money basically has not been paid by the debtor and there is a default committed on part of the debtor. So either it can make application itself or jointly with other financial creditor or any other person notified. This was also an amendment, or any other person notified, but it was not the latest amendment, the one attempt back amendment. Or any other person notified in this behalf, that is guardian, executive, administrator, estate. Okay, whether this let it be. Okay, so just remember, itself or jointly with other financial creditor or other person notified in this behalf, that is guardian, executor, administrator or administrator of the estate, trustee including the debenture trustee person duly authorized by the board. Okay, now required with application. So what will be, he will be required for along with the application, evidence in support of the default, that is the records of the default recorded with the information utility. So the default records has been recorded with the information utility, so we will have to attach the evidence of that in support of the default. Then he has to propose the name of the IRP. It is not optional, it is mandatory. Name of an IRP he has to propose, and any other specified information. Now if the operational creditor makes an application, that is operational creditor, first what he will do is not make directly application to NCLT, but will give demand notice. And see, this is a proper process. If there is any breach, so means it is not complying with the provision. So first there should be serving of any demand notice and the copy of invoice from the operational creditor to the corporate debtor. Then the corporate debtor within 10 days of the receipt intimate about the existence of the dispute, if any. So if there is any dispute, it will either respond within 10 days along with the record of any pendency. It will also proof that along with the records of the pendency of any suit, arbitration, or the details of any unpaid operational debt in case the debt has or is being paid, or the detail of the payment. Okay, so there can be two things, that either within 10 days he can of receipt intimate the existence of dispute, or he will make the payment, the detail of the payment of any unpaid operational debt. So whatever is the unpaid debt, he will pay to them, that he will pay to the operational creditor. If after 10 days the operational creditor does not receive his payment or the confirmation of the dispute that existed before the demand notice was demand, so that dispute should be existed. See, as they were given very clearly that dispute should be existed before the demand notice was sent, he may file an application before the adjudicating authority for initiation of the corporate insolvency resolution process. So he can file if it is not received within 10 days the payment or the existence of the dispute. Okay, required things with the application: evidence in support of the default. There has been amendment in this as well, not the latest, but the one attempt earlier there was amendment. Evidence in support of the default: the copy of the invoice demanding the payment. So first evidence in support of the default. Wait a second. Evidence in support of the default: first, the copy of the invoice demanding the payment, the invoice copy which the operational creditor has submitted to the corporate debtor at the initial step. That is the copy of the invoice demanding the payment, or the demand notice, the demand notice or the copy of invoice. Then second, affidavit that no notice is given by the corporate debtor relating to the dispute of an unpaid operational debt. So he will give an affidavit that the no notice of any what we can say, the pendency of any dispute is given by the corporate debtor relating to the dispute of any unpaid operational debt. Then third, copy of the certificate from the financial institution maintaining the records of the copy of the certificate from the financial institution. So we will take the records, certificates from the financial institution maintaining the records of the operational creditor confirming that there is no payment of any unpaid operational debt if available. So we will give the certificate from the financial institution that no payment has been received from the of any unpaid operational debt if available. Then copy of any of the records with the information utility confirming that there is no payment of any unpaid operational debt. So copy of record with information utility, a copy of record from the financial institution that no payment has been received, a copy of records from the information utility that no payment has been received of an unpaid operational debt. Then any other proof confirming that there is no payment, or any other proof. So what all are the things we need to attach is: first, copy of invoice demanding the payment or the demand notice. Then affidavit that no notice is given by the corporate debtor relating pendency of any dispute. Then certificate from the financial institution maintaining the accounts of the operational creditor, confirming that there is no payment of any unpaid operational debt if available. A copy of any records with the information utility confirming that there is no payment of an unpaid operational debt if available. Any other proof confirming that there is no payment of an unpaid operational debt. Any other proof that is no payment of an unpaid operational debt. Name of an IRP. Over here the giving of a name is not mandatory. Any other special information. Okay, any other special. Corporate applicant. Now the corporate if the corporate application makes an application to the NCLT for the IBC insolvency process, so the required thing with the application is particular relating to the books of accounts and the, so corporate applicant is basically corporate debtor only. Corporate required, first thing, particulars relating to the books of accounts and other documents. So he will have to submit that person, not he, it will have to submit the books of accounts and other documents. Name of the IRP, here also it is mandatory to submit the name of the IRP, and SR passed by the corporate debtor, or the resolution passed by at least 3/4 of the total number of the partner of the corporate debtor. So resolution passed by at least 3/4. So SR passed by the corporate debtor, or if it is a partnership firm basically, or a resolution by at least 3/4 of the total number of the partner of the corporate debtor. So special resolution or resolution by at least 3/4 of the total number of the partner of the corporate debtor. 3/4 of the total number of the partner of the corporate debtor. So we are done with this application thing. We'll see the definition of corporate applicant. The second definition: corporate applicant means corporate debtor, a member or the partner of the corporate debtor who is authorized to make the application for the purpose of for the corporate insolvency resolution process under the constitutional document of the corporate debtor. So a corporate debtor or an member or the partner who is authorized to make an application for the corporate insolvency process under the constitutional document of the corporate debtor. Then an individual who is in charge of managing the operations and the resources of the corporate debtor. So that individual, first of all, an individual who has been authorized, an individual who is in charge of managing the operations. So who is managing the operations and the resources, who is a person in charge who is operating the operations, managing the operations and resources of the corporate debtor. That individual is termed as corporate applicant, or an person who has control and supervision over the financial affairs of the corporate debtor. So a corporate debtor itself, or an partner or an member or the partner who is authorized to make an application for the corporate insolvency resolution process under under the constitutional document of the corporate debtor. Then person who is an individual who is in charge of the operations, who is in charge of the managing the operations and the resources. Person who is managing the operations and the resources. Okay, so who is managing the resources, who is managing the operation, that individual, person in charge. And and the last one, who has the control and the supervision over the financial affairs. So managing the resources is day-to-day activity, managing the resource, managing the operations, that person in charge, that individual. And that person also who has the control and supervision over the financial affairs of the corporate debtor. Okay. The adjudicating authority may allow the withdrawal of the applicant admitted on an application. This is also an earlier amendment, not the immediate one. The adjudicating authority AA may allow the withdrawal of the application admitted. The one application which has been admitted, that can be allowed to be withdrawn on an application with the approval of 90% of the voting share of the committee of creditor. If there is an if 90% of the committee of creditor makes an application for the withdrawal, then the application which has been admitted can be withdrawn. Person not entitled to initiate the corporate insolvency process. Who are the person not entitled? The corporate debtor and the financial creditor. So first we'll see in relation to corporate debtor three points. That is, in corporate debtor who is already undergoing an insolvency resolution process, in respect of whom the liquidation order has been made, so he is already going on resolution process. Second, who has, again, in respect of whom the liquidation order has been made. Third, having the complete corporate insolvency resolution process, having completed the corporate insolvency, that corporate debtor has having completed the corporate insolvency resolution process 12 months preceding the date of making of the application. So the date of making of application he has completed within 12 months only. He has means once the insolvency process has been completed, corporate insolvency resolution process, and within 12 months he is making an application. Or a corporate debtor or the financial creditor violated any of the provisions, violated any of the terms of the resolution plan. So after the at the end of the resolution process, if they agree on to a resolution plan, the resolution plan, if it is approved by the adjudicating authority, then they have to basically work on that plan. So now if the corporate debtor or the financial creditor has violated any of the terms of the resolution plan which was approved 12 months before the date of making of an application, so corporate debtor or the financial creditor has violated any of the terms of the resolution plan which has been approved 12 months before the date of making an application. Note, for this section, the corporate debtor includes corporate applicant in respect of the corporate debtor. Okay, it includes corporate applicant in respect of the corporate debtor, and nothing in this section shall prevent a corporate debtor in any case referred above from initiating of the CIRP against the corporate debtor. So what they're given is, nothing in this section shall prevent a corporate debtor in any case referred above from initiating the CIRP against another corporate debtor. Okay, so over here the restriction to corporate debtor is for making an application for itself. It is but if one corporate debtor can make an application for the another corporate debtor, if we want to initiate the corporate insolvency resolution process, so one corporate debtor can make an application for the another corporate debtor. It does not make restriction on this making of application. Okay, then admission or the rejection of an application. NCLT may either accept or reject the application within 14 days of the receipt of an application. 14 days they will either accept or reject the application. In case of any of the defect, the application shall be given within 7 days. In case of any defect, if there is any defect, for instance, the applicant, the one who is making application, the applicant shall be given 7 days from the receipt of the rejection notice to rectify it. So within 14 days they will accept or reject. If they have rejected, so from the date we had received, we will get 7 days to rectify the defect. However, if the NCLT had ascertained the existence of any default and has passed the order within such a time, if the NCLT has not ascertained, it is not ascertained, but NCLT has not ascertained the existence of the default and passed an order without such a time, it shall record its reasons in writing for the same. So okay, if it does not wait for the rectification by the applicant basically for 7 days, and if it does not find that there isn't any existence of any default and pass an order within such a time, so if it want to pass an order, it shall record the reasons in writing for the same. The corporate insolvency resolution process shall commence from the date of an admission of an application by the NCLT. So from the date on which they have admitted the application, that is accepted the application, the corporate insolvency resolution process will begin okay, it is referred as corporate insolvency commencement. Then once the corporate insolvency has been commenced, basically there will be a moratorium being imposed. That is, there will be a stay on all the proceedings, on all the acts of the against the corporate debtor. But there are exceptions to this as well. That is, what all activity are permitted during moratorium, and what all activity, and they had also specified the activities which are prohibited during the moratorium. Okay, we'll read. The NCLT will declare the moratorium period during which no action can be taken against the company. So they will impose the moratorium period during which no action will be taken against the company or the assets of the company, to keep the company on a going concern. That is, all the suits and the legal proceedings, etc., against the corporate debtor shall be in abeyance. So all the suits, all the legal proceedings against the corporate debtor will be in abeyance. The following act shall be prohibited during the moratorium. First, institution or continuation of any of the suit or the proceedings against the corporate debtor, including the execution of any judgment, decree or order in any court of law, tribunal, arbitration panel or any other authority. That's what they are given is, there will be a stop on all the proceedings, pending litigations and all things. That is, these specific acts are prohibited during moratorium. First, institution or either to institute, to begin, or continuation of any of the, if there is any continuing suit, it will also there will also be stay on that. That is, in institution or continuation of any suit or the proceedings against the corporate debtor, including the execution of any of the judgment, execution of any of the judgment, decree or order in any court, judgment, decree, order in any court, law, tribunal, court of law, tribunal, arbitration panel or other authority. Second, any action to foreclose, recovery or enforce any security interest created by the corporate debtor in respect of its property, including any action under the Sarafasite. So there will not be any what we can say, there cannot be any action taken against under the Sarafasi Act as well. That is, they cannot enforce any security interest. So any action to foreclose, recover or enforce any security interest created by the corporate debtor in respect of its corporate, wait a second, subjected to no default in the payment of current dues arising for the use of the subjected to no default in payment, subject to no default. If there is no default, subjected to no default in the payment of any current dues arising there has been a stop, but I couldn't recognize while recording. So I think so the last point which I discussed is the following acts which are prohibited during the moratorium. We will again quickly revise from there. So there are 4 points which are prohibited: institution or the continuation of any of the suits or the proceedings against the corporate debtor, including the execution of any judgment, decree or the order in the court of law, tribunal, arbitral tribunal or other authority, any action to foreclose, recovery, so the first point is done. Any action to foreclose, recover or enforce any of the security interest created by the corporate debtor in respect of any of its property, including any action under the Sarafasai Act. Third, recovery of any of the property by any owner or the lessor where the property is occupied by or in possession of any corporate debtor. So recovery will be seized, basically will be stopped, will be stayed by any of the owner or the lessor where such a property is occupied or in possession of any corporate debtor, transferring, encumbering, alienating, disposing of the corporate debtor this all thing will be prohibited, that is transferring, encumbering, eliminating, disposing of any of the corporate data of any of its assets or the legal rights or the beneficial interest. The following act then the following acts shall not be prohibited during the moratorium. There are 3 acts. First is a supply of the essential goods and the services of any corporate debtor as may be specified. Second, surety in a contract of a guarantor to a corporate debtor, surety in a contract of guarantee to a corporate debtor, surety in a contract of guarantee to the corporate debtor. And the third is notified transaction by the CG in consultation with the financial regulator. So any of the notified transaction in consultation of in CG, any of the notified transaction by the CG in consultation with the financial regulator. So in consultation with financial regulator, if the CG notifies certain transaction, that will also be not prohibited during the moratorium. The order of the moratorium shall have the effect from the date of such an order till the completion of any corporate insolvency. So till the completion of any corporate insolvency resolution process, moratorium will have the effect. However, if the adjudicating authority approves the resolution plan and passes an order for the liquidation, so when it approves the resolution plan or passes an order for the liquidation, the moratorium will cease to have the effect from the date of such an order. Note, notwithstanding anything contained in the license, permit, registration, quota, concession, clearance, or any of the similar rights or similar grant or rights given by the central government. So any of this license, permit, registration, quota, concession, clearance, any similar grants, rights given by the central government, local authority, sectoral regulator, or any of the authority shall not be suspended. So these all thing will not be suspended or terminated on the ground of any insolvency. Subjected means it will not be suspended on the ground of insolvency, but subjected to means unless and until there has been a default of payment of any current dues. So subjected to no default in the payment of any current dues arising for the use or the continuation during the moratorium period. So there should be no dues, basically not a current dues. It will not be stopped just because of the insolvency, but there should not be dues in payment of any current dues arising on the use of any continuation during the moratorium period. If the second note, if the IRP considers that the goods and the services critical to protect and preserve the value and managing operation of the corporate debtor as a going concern. So if the IRP feels that a certain supplies of any goods and services are critical for the managing, preserving, to protect and preserve the value and managing the operation of the corporate debtor. So any of the activity which are necessary, that is supply of any goods or the services, then the supply of such shall not be terminated. So supply of such shall not be terminated, suspended, or interrupted during the moratorium, except if the dues arising from such a supply. So if there isn't been a due on such a supply, dues arising, so it will not be stopped. It will not moratorium will not have any effect on that supplies which are critical to protect and preserve and to manage the operation, except if the dues arising from such a supply during the moratorium are not paid. Okay, so we are done with this. Now the concept of insolvency resolution professional. IRP is appointed by the NCLT on the commencement date, that is on the date on which an application has been admitted. This is an amendment. This we will see in the amendment sheet later on. This separately we will also see the amendment, and this is also an amended sheet from which we are currently revising. So IRP is appointed by the NCLT to manage the affairs of the corporate debtor till the date of any appointment of any resolution professional by the committee of the creditors. So till the date COC appoints the RP, IRP will manage the affairs of the corporate debtor. If the application was filed by the financial creditor or the corporate debtor, the insolvency professional proposed shall be appointed as an IRP. So the name which they have been given as an proposed insolvency resolution professional, that will be appointed if no disciplinary proceedings are pending against him. If the application was filed by the operational creditor and no proposal for the IRP was made. So there were an option for the operational creditor, either they can propose the name of an IRP or they cannot propose the name of an IRP. So if they are proposing the name of an IRP, if they are not proposing the name of an IRP, then the NCLT may make a reference to the IBBA. So and now what NCLT will do, if they have not proposed, so they will make a reference to the IBBA for the recommendation of any insolvency professional to act as an IRP. IBBI shall recommend the name within 10 days of the receipt of such a reference from the adjudicating authority, that is the NCLT. From the date of the reference from the NCLT, it shall within 10 days refer the name. However, if an IRP was proposed, so if the operational creditor has proposed the name, such a person shall be appointed if no disciplinary proceedings are pending against him. Power. What are the powers of the IRP? There are 4 major powers. that is management of the affairs, exercise of the powers of any board. So it will manage the affairs of the corporate. Second, it will exercise all the powers and the of the board and the partners which are exercised by the person earlier. Now it will be with the IRP, and he will exercise all the powers. Then reporting of an officer and the manager. The officer and the manager of the company who are reporting to the top management of the corporate debtor, now they will report to the IRP. And instruction to the institutional financial institution. So they can also instruct the financial institution to provide any details, to provide the detail with any of the information relating to the corporate debtor. So we will read in detail. Powers: management of the affairs. Shall vest in the IRP from the date of its appointment. From the date it is appointment, it will the management will vest with the management of any affairs will be with the IRP. Exercise of any power of the board of director and the board of director and partners. The power of the board of director and the partner of any corporate debtor shall stand suspended. So their power will be stand suspended and will be exercised by the IRP. Reporting of the officer and the manager. So they will report basically to the IRP and provide the access to the documents and the records as the case may be required by the IRP. So they will report to the IRP and they will also provide access to the documents and the records. They will provide access to the they will report to the IRP and they will provide access to the documents and the reports and the records as the case may be required by the IRP. Instructions to the financial institution. The financial institution maintaining the accounts of the corporate debtor shall act on the instruction of the IRP in relation to such an accounts and furnish all the information relating to the corporate debtor available with them to the IRP. So what they are given is that instruction to the financial institution, the financial institution maintaining the accounts of the corporate debtor. So the financial institution, the bank basically, or the other financial institution who are maintaining the accounts of the corporate debtor shall act on the, that institution will act on the instruction of the insolvency resolution professional in relation to any of the accounts or in relation to such an accounts, and furnish all the information relating to the corporate debtor available with them to the IRP. So what they will do, they will act on the instruction. First they will act on the instruction of the IRP, then all the accounts what they will do, instruction of an IRP in relation to such an accounts, and they will furnish the information relating to the corporate debtor which are available with them to the IRP. So they will furnish the information which is available with them of the relating to the corporate debtor. They will submit it to the IRP, and they will also act on the instructions of the IRP. Now duties, these were the powers. Now what is the duty of the IRP? Receive and collect the claim. This we had seen in what we can say in the 5 pillars point, insolvency professional point as well. That is, their duty is to receive and collect the claims of the creditor. They will collect the claims, then constitute the committee of creditor, collect info relating to the corporate debtor, file info collected with the information utility. Now what they will do is first collect the claims, then form committee of creditor. They will collect the information relating to the corporate debtor. That information which they have collected, that they will submit it to the information utility, so that the information can be saved in the electronic database, centralized electronic database. Then what they will do, they will monitor the assets. They will manage the business basically. So they will monitor the assets, take the control of the custody of the assets over which the corporate debtor has the ownership right. So all the assets over which the corporate debtor has the ownership right, they will take the custody, they will manage, they will take the control, they will monitor the assets, monitor, that is check, they will verify, they will check they will keep an eye, that is monitor the assets, they will take control, they will have the custody of the assets which are owned by the over which the corporate debtor has the ownership right. Perform such other duty as may be specified. So we will again revise basically. Collect, receive and collect the claims, constitute a committee of creditor collecting information relating to the corporate debtor. So the corporate IRP will collect the information relating to the corporate debtor. That way IRP will file the information collected with the information utility, monitor the asset, take control, take custody of any of the assets over which the corporate debtor has the ownership right. Perform such other duty as may be specified by the board, that is IBBI. Note: the assets shall not include the asset owned by third party or by the subsidiary of the corporate debtor or the notified assets. So it will not include, first of all, the notified assets. It will not include the assets of any third party. It will not include the assets of the subsidiary of the corporate debtor. Now, public announcement. This IRP basically does a public announcement on its appointments. Now, see what the within 3 days, what they have given is IRP shall make an application. IRP shall make an application. Sorry, what I am reading here. IRP shall make a public announcement. So IRP, what they will do is, first they will make the public announcement of the initiation of the corporate insolvency resolution process in Form A immediately within 3 days from the date of his appointment, specifying the name and address of the corporate debtor. So they will make a public announcement of the corporate means that is initiation of any corporate insolvency resolution process in Form A. That public announcement will be in Form A. That will be basically for initiation of the corporate insolvency resolution process, and that will be within, they will make a public announcement immediately within 3 days from the date of an appointment, specifying from the date of his appointment. Within 3 days he will make a public announcement specifying first the name. What is the name of the see, he is managing corporate debtor, so there will be a name of the corporate debtor. So name, address of the corporate debtor. Second, name of the authority with which the corporate debtor is registered. So it is simple, name and address of corporate debtor, name of an authority under which the corporate debtor is registered. Third, detail of the IRP vested with the management. So he will give that IRP will basically give the detail of his, that is details of the IRP vested with the management of the corporate debtor. That is who is an individual who is managing the affairs, who is managing the business of the corporate debtor and responsible for receiving the claims. That who is an individual who is responsible for receiving claim, who will receive the claims of the creditor. Then wait a second. Is they will specify in third point we have seen that the detail of the IRP who have been vested with the management of the corporate debtor and the responsible for receiving of any claim. Then fourth, last date for the submission of the claim, which is the last date basically for the submission of the claim. Then penalty for the false or the misleading claim. Then what is the penalty basically for the last date for the submission of the claim, that creditor will come and submit their claims. Then penalty for the false or misleading claims, any person cannot come and claim, so there is a penalty for the false misleading claim. Then the date on which the corporate insolvency resolution process shall close, that is from when it has begun, and within 180 days they have to close. So what is the last date of the CIRP? So they will give the name and address of the corporate debtor, the name of an authority under which the corporate debtor is registered, the details of the IRP who is in charge of any management of any affairs of the corporate debtor. Then the last date of the submission of any claim. Then the what we can say, the last date. Then a penalty in case of any misleading or false claim, and they will also give the last date for the of the corporate insolvency resolution process. So the date on which the corporate insolvency resolution process shall close basically. So last date for the submission, they will also give the last date when the resolution process will close. The expenses of any public announcement shall be borne by the applicant, which may reimbursed by the committee of creditor to the extent rectified. See what they are given is the expenses of the public announcement, the expenses which is incurred, that is documentations and other expenses for collection of any claim and what all things, the expenses which of the public announcement shall be borne by the applicant who is making an application, which may be reimbursed by the committee of creditor to extent rectified. It is simple, the expense of any public will be borne by the applicant, and that will be reimbursed by the committee of the creditor to the extent rectified. Okay, so now from committee of creditor will cover in the next video. Till now we will stop. So we have seen basically, see, when the corporate insolvency resolution process start, there should be a default, then filing of an filing of the claim before the NCLT, who will file financial creditor, operational creditor and the corporate debtor. Financial creditor and corporate applicant will have to mandatorily give the name of the IRP, and operational creditor does not have to mandatorily give. Then operational creditor have to perform some another additional things, that is they cannot directly make an application to the corporate debtor. Wait a second. That is, the operational creditor have to submit the notice demand and the copy of the invoice as well, in addition to this, and they have to submit the required applications also with the required detailed documents also with the application. Then the withdrawal, they can withdraw the application. See what they're going is, the adjudicating authority may allow the withdrawal of the application on the withdrawal of the application admitted by on an application with approval of 90% of the vote of the committee of creditor. Then the person who cannot initiate the insolvency process is corporate debtor and corporate financial creditor. They have given that who is already undergoing or against whom liquidation order has been passed, or who has corporate insolvency resolution process has been completed 12 months before, or whether the corporate debtor or the financial creditor has committed any default. Then within 14 days, one corporate debtor is not restricted to file an CIRP, an application for CIRP against another corporate debtor. They can file. Then within 14 days they will have to admit or reject. Then if there is any defect, then applicant can rectify it within 7 days. Once it is admitted, the corporate insolvency resolution process will start, and then from that period moratorium will start basically, and it will end. During the moratorium, the following acts are restricted, are prohibited basically. First, institution of any claim, then enforcement of any security interest, and recovery of any property by the owner or the lessor, and transferring, encumbering, alienating, disposing of. Then a supply of any essential goods is not prohibited. Then surety in a contract of guarantee to the corporate debtor and any other notified transaction by the CG in consultation with the financial regulator, then that is not prohibited basically. The notwithstanding anything license permitted, see the license, registration, quota, concession, this will not be cancelled unless there is any default in the current dues arising from such a continuation of any moratorium period. Or we can say that the goods and services which are necessary, which are critical to protect, and the supply of any goods and services critical to protect and preserve the value and the managing the operation of any corporate debtor, if that is important enough, so that will be continued. The IRP will continue that unless there has been a default in the payment arising from such a dues, except if the dues arising from such a supply during the moratorium are not paid. And then we have seen that the IRP will be appointed on the commencement date. Then if they have given the proposed the name financial creditor or the corporate debtor, then they can be appointed if no disciplinary proceedings can IRP will be appointed if no disciplinary proceedings are pending against him. Any operation, in case of any operational creditor, what the NCLT will do, refer to case to the IBB. Within 10 days they will refer. And if they have proposed the name, for instance, this was the case where they haven't proposed the name, and if they have proposed the name, that is operational creditor has proposed the name, so the IRP will be appointed if no disciplinary proceedings are pending against them. Then their power, that is management of any affairs, exercise of any powers of the board, then exercise the powers of the board, then reporting of any officer, manager, reporting of any officer and manager, they will report. Then instruction to the financial institution, they will instruct basically. They shall and the financial institution shall act on the instruction of any IRP, and they shall furnish all the information related to the corporate data available to them with the IRP. Then what we can say, their duties, that is to collect the claims, constitute the committee of creditor, collect information related to the corporate data, file information with the information entity, monitor the assets, take control, custody of any of the assets which in the corporate debtor has, over which the corporate debtor has the ownership right, perform such as the duty as may be specified. Then they cannot have the control over the assets of the third party of the subsidiary of the corporate debtor or notified assets. Then public announcement it shall made on the appointment of any IRP. The IRP will immediately within 3 days will make a public announcement from the date of his appointment, specifying the name and address of the corporate debtor, name and the name of the authority under which the corporate debtor is registered, detail of the IRP vested with the in management of any corporate debtor and responsible of receiving the claim. So who is the IRP? Basically the detail of the IRP, last date of submission of the claim, penalty for the false and misleading claim, then date of the date on which the IRP shall close, the date on which the CIRP shall close, the expenses of the public announcement shall be borne by the expenses of the public announcement. The expenses of the public announcement shall be borne by the, see what it is given, that expenses of the public announcements shall be borne by the applicant which will be reimbursed. Okay, that expenses will be borne by the applicant, which will be reimbursed by the COC if extent rectified. And the next step, we will see the committee of the creditor in the next part of the video. Okay, thank you.